I really love your lectures. You're so funny.
Oh, thank you, thank you. I'm just keeping it. You guys contribute a lot when you speak with your own voice. I am still not sure whether I actually logged out here. What is this now?
Oh, I'm sorry. That was like fading. I'm tired and ill.
Oh, don't worry. I can tell you were a little interpreted. Guys, I think we need to vacate
I
here.
promise it's not you. It's me.
Okay.
Ill and tired. Can I ask you a question before you walk?
Yes, let's. How do I log out? I genuinely don't know.
So,
Because I hate it when I find somebody else logged
yeah.
in.
Is it weird? How do we log in here?
I go to e-learning.
And then that's. Where's the e-learning then?
Go to. Let's go to e-learning or just kids, and then I can tell. I usually keep checking whether I'm still logged in. That's one way of doing it.
It's like everything that could possibly go wrong. Got it.
Oh no!
I wonder why.
Wow. Okay, am I still logged in now?
Here, what if we go with this?
I'm still logged in.
Okay.
Wait. Oh, okay.
But it's you, isn't it? You're the guest. Is that correct?
Yeah. Can we check out all? Yeah. Otherwise, the other person may not get in.
Yes.
Try these little thingies.
This?
Exit. Try that.
That I think is just to exit the page. Yeah. So let's do this. I have the same thing. So. Okay.
So I would
It
be
seems
like
like we've backed out. I think you're not logged in anymore.
Alright.
Because it was a guest page.
Okay.
And so if you go back to the home, it makes you, because in the first screen we selected don't keep me logged in.
Okay.
Once you go back to the home.
Okay.
But it's wildly confusing, so I
It is wildly confusing.
Right, so apart from the lack of any lights and the screen, everything's going very well. Anybody have any experience of this classroom? The lights, yeah. Welcome. Future references. The button needs to be pressed. Okay, so all I need now to do is to get rid of this. Does anybody have any more idea than I have? I'll tell you what, should we, rather than waste any more time, just run and do something with the screen that we've got available, unless anybody has any bright ideas. Okay. So, we were talking about the discretionary element on Tuesday. And it's probably best if I recap where we got to, and then we can pick up straight away from there. Can everyone see if I just use this bit of the board? Okay. So, just a reminder, I know you've seen this diagram a load of times now. So we were looking at jurisdiction as of right, and we were looking at service out. On this side, we've got our bases of jurisdiction, and we've got our discretionary element. On this side, we said it wasn't a clear, bright line. You've got your CPR practice direction 6b, paragraph 3.1. You've got your serious issue on the merits, and you've got your discretionary element. Where else have we got to? Well, we've been looking at the discretionary element part of on this side of the equation so far. We haven't looked at it on this side of the equation yet. We had seen from Spiliada chiefly this two-limb test for granting a stay of proceedings. And we know that the first limb was that the defendant has to show a clearly and distinctly more appropriate forum. I should say a clearly and distinctly more an available forum that is clearly and distinctly more appropriate. But I might as well ask you. Okay, we've done that on this side of the equation, and we were then looking at the second stage, which was that if and only if the defendant has done that, the defendant will get a stay unless it can show reasons. Unless the defendant will get a stay unless the claimant can show reasons of injustice to it why a stay should be granted. By the way, this room is a reminder. I've taught this room like this before that it could always be worse. These rooms with no windows and often very hot with lighting issues and quite often musical accompaniment actually in other rooms. I think what we've talked about basically until now is things that aren't relevant under the injustice element. We've talked about different rules of discovery, certainly higher damages. We've talked about time limits are normally going to be irrelevant because, frankly, you've only got yourself to blame if you let time run out. And I think what we've got to now is basically things that might be more relevant. Things that we've given quite a lot of examples of things that would not be injustice. So let's take an example of something that might be relevant. It's not in the book, but I mentioned it to you on Tuesday. The example of the case of Luba that I mentioned, Luba and Kate. Just to remind you, we had 3,000 mine workers in South Africa poisoned with asbestos, or claimed to be poisoned by asbestos poisoning, claimed brought by them or by their widows. All of those South Africans, you've got 3,000 South Africans, and the company they worked for was quite clearly a South African company too, but it was a subsidiary, And it was said also that the parent company basically had a lot of control over the subsidiary and directed how it had a say over the conditions of employees in the subsidiary company, although formally a separate company. The subsidiary company, the link is that the parent company at least is English. Although that is not the party being sued. The party being sued is the subsidiary. So there were a couple of problems with the proceedings in South Africa. One problem was a lack of an effective, or at least the court accepted, an effective group litigation procedure, a way of dealing with, in the US you may have heard of class actions as a way of dealing with massive numbers of claims. UK law doesn't have anything quite as far-reaching as a class action, but it does have some procedures where huge groups can be represented through a larger number of typical claimants. I think in this case there were about 9. But they are effectively advancing the case because their case is the same case as everyone else, in this case negligence or breach of contract. And then only at the end does the court try and work out what the extent of the damages is or the losses for each individual. Okay. Apparently South Africa didn't have any kind of procedure that could handle this. So we were talking about 3,000 people having to bring 3,000 different claims. That was point 1. Point 2, and perhaps even more profoundly, these people didn't have the money to litigate in South Africa. South Africa didn't have, or at least it was accepted, it didn't have a sufficiently far-reaching system of legal aid, so public money, to help these people pay for their litigation. And most of the claimants were, at the time, and it's become less generous since then, I'm afraid, were eligible for legal aid in England, despite being South African claimants, eligible for public money to bring their cases in English courts. And the ones that weren't had evidence that they concluded so-called conditional fee arrangements. What's a conditional fee arrangement? Very popular in the US. Yeah.
An arrangement where a law firm agrees to not to collect money or not to pay fees, to do the case with his money. At the end of the day, if he wins, he take a percentage. If he loses, the litigant
Exactly. And sometimes it's quite a gamble for a law firm. So often the percentage is quite high they end up taking if they win, but they only charge you if they win their case. Different, not quite the same factors, because of the conditional fee is a private person who's basically taking the risk as employer. Legal aid is obviously public money that's involved. But this is a pretty stark case under the second level. We've already seen, I talked about it on Tuesday, the House of Lords, as it then was, before our Supreme Court, so it's still the highest court, didn't accept the argument from the defendants that the claimant had failed to prove that South Africa was an available forum. We talked about that beforehand. South Africa, of course, had jurisdictional right. There was no problem with that. The problem was a practical one. How do you actually bring the proceedings there? You haven't got any money. And the lack of a group litigation. So the claimant's second argument is, well, if you're against me on that, I didn't even argue, the claimants didn't even pretend that England was the appropriate forum. Well, that wasn't even what they were saying, because quite obviously it wasn't. What they said was, it would be a profound injustice if you send us to litigate in South Africa knowing full well that will be the end of it, we will never get justice, because we will not be able to sue anyone. Now, notice, England is a pretty strong second best here in terms of the connections. Nobody could say the connections to England were anything like as strong as South Africa. But there's no other forum in town. It's not like there were 3 or 4 different countries where you could say. The English courts had the starkest possible problem. If it wasn't England, it wasn't us in England, it was quite obviously nowhere. The House of Lords has a very difficult, but also from our point of view, very, very interesting question. Should you let somebody sue here under the second limb of the Spinny-Arthur test on the basis, almost exclusively the basis, that they can get public money in England to litigate, but they can't afford to bring the proceedings in the so-called natural form. Now, whether you know what happened in the case or not, it's almost more interesting to discuss the principle of it. Because I think there are arguments, perhaps either way. Does anybody have a view on that sort of question? Whether the English courts. You see, the delicious thing about this is, if you have something like the European rules, which are just fixed rules, if this happens you have jurisdiction, if that happens you don't, you never get, it's much clearer, you never get into these very tricky, sensitive questions, which when you have a discretionary system like the English system, you have to face directly. Okay? It enables you to deal with the individual facts, but it gets you into some very awkward questions. Does anybody have a view about whether the South African claimant should or should not have been allowed to sue here by raising this second limit? Yeah.
If you can't have a procedure in South Africa because there is basically no legal aid in Europe, we would probably assume that that's a breach of Article 6 of the Convention on Human Rights.
Okay.
And on this basis, that would be an argument to accept the claim in UK.
That's a very interesting thing you said. One of the things the claimant said was that their Article 6 HR right, that's the, for those of you who don't know, simply the right to a fair trial, would be breached if they weren't allowed to sue in England. And what they said was, they put it two ways. Either they said, look, it can't possibly be that if we're denied our Article 6 right, it's not a relevant factor under the second limb of the test, it must be. Or they said, if the second limb of the test is not sufficiently sensitive to deal with cases where Article 6 of the ECHR is being breached, then the court must be subject to a separate and completely additional requirement, separate to those, that it must take jurisdiction, if otherwise the claimant's right to a fair trial will be breached. So whether you regard it as a subset of this test, just one example of an injustice is where your Article 6 right is breached, or something completely separate. It was one argument that the claimant made, right to a fair trial. On the other hand, it doesn't matter how unfair your trial is, you wouldn't get away with that argument under the European rules of jurisdiction, I can tell you, because there is no such principle. It's either the rule says you have jurisdiction or a rule says you haven't. And that's exactly the point. You're into very sensitive questions. Does anyone else have a view? Does anyone perhaps have a view that though one can be very sympathetic to what was a tragic set of facts, that the right thing from a legal perspective was to say, I'm sorry, you can't sue them? Does anyone have that sense? Think about public money, for example.
I mean, from my perspective, it's a bit difficult to burden our legal system resources, or at least with cases that have nothing to do on very
I mean, if you're being hard-headed about it, you can't. The English public funding system cannot be available to the entire from the entirety of the world to turn up and say, I can't afford to bring my case here, therefore I have a right to a fair trial somewhere, therefore you must give me public money and let me sue. That's, I think, the sort of point you're making. Particularly by definition, as these are cases which, if you're deciding who is eligible for public funding, okay, you discuss their merit and how much work they've got. But it's not unreasonable to ask how much connection do they and their claim actually have with England. Because there's only a finite pot of public money, as we know. And by definition, if these people are suing here using English legal aid, public money, then other people are not getting legal aid to sue them. And that's one of the things that House of Lords was very, very concerned about, that they couldn't lay down a principle as broad as, I don't think you were suggesting it, but as broad as whenever somebody can't afford to fund their case abroad and can afford to fund it in England, they should be allowed to sue here under the second limb, because you can see, sometimes called in other areas of law, a floodgates problem. If you let this particular group of people in, how can you ever stop anybody coming in who's running exactly the same argument? Okay? And the House of Lords was very sensitive to that. On the other hand, this was a very unattractive case to send away, because like I say, there was only one other, the only possible place in the world where these claimants could sue, apart from South Africa, was England. Now you might say, if you're suing a South African subsidiary, it's pretty tenuous to say, well, they had an English parent company, because we know by now a subsidiary is a separate company to a parent. On the other hand, this was, as I say, a very uncomfortable case. There was evidence, of course it was only at the jurisdiction stage, that the parent company very heavily involved with what the subsidiary did. If there had been connections to other jurisdictions, I think the English court might have hesitated more. But the court's ultimate conclusion was, look, we are not going to say that anybody who can't afford to fund their litigation overseas is entitled to litigate in England. We're specifically not going to say that. But we are going to say on the fact that the second limit is intended to be sufficiently flexible to be fact sensitive to each case. And this is a case where the bare fact is that if the claimants can't sue in South Africa, they obviously can't sue in England, they obviously can't sue anywhere in the world. And that would be a grave affront to our notions of justice and fair. So they were allowed, and House of Lords, they were allowed to sue him. And the reason was specifically that justice element of the discretionary test. 3,000 people who really, in terms of the natural forum, were quite obviously not sued in the natural forum, were allowed to sue him on the basis of the injustice that was suffered. Now, you mentioned Article 6. I don't think that the implications of Article 6 have yet been 100% thought through by the English courts. And you can feel in the judgment of the House of Lords that they were not going to move that away. They were not going to say, they were not going to find that there was an additional requirement under the discretionary element that they must take jurisdiction in where the defendant's right, the claimant's right to a fair trial would be defeated. And all the court basically said, which is perhaps not surprising, is it's impossible to imagine a case where if someone was really being denied their Article 6 rights to a fair trial, where we wouldn't invoke the second limb of this test anyway, you know, and therefore Article 16 is actually irrelevant. It doesn't add anything to our injustice case, because every example of a breach of Article 6 would be, of the ECHR, will be an example of an injustice under this rule. And like I say, it would be an interesting question if anyone ever goes to challenge in Strasbourg to an English court's decision not to treat it as something, an injustice that's relevant, on the basis that they've been denied an Article 6 right to a fair trial. I think that's a very interesting subject. People have started to write on this a bit, but it's not really, Article 6 has not had the impact yet you might be expected on this text. So that's, I think, quite a good example, Louver and Cape, of an injustice. Any questions on that before I move on? I want to now, we're going to have a look at another example of injustice, but I want to go back. I'm conscious we haven't looked at how the discretionary element applies on this side of the equation yet, so that's where I'm going to go back to now. And I'm conscious that involves some jumping around. I think this is the best way to do it. So, going back to our friend service out the jurisdiction, remember the claimant's got to show three things, for the burden is on the claimant on this side for everything. Good arguable case that you fall within one of those bases for service out that we looked at a couple of sessions ago. Serious issue to be tried on the merits, some prospect of success. And what I keep calling a discretionary element. What is this discretionary element? What does the claimant have to show?
For non-convenience, that the English court is the appropriate court.
Yes. You can say forum non-convenience the other way around.
Yes.
Take out the word non then, and you pretty much get the answer. Forum convenience. Yeah? The claimant has to show that England is the proper forum, also just called the natural forum. And I repeat, the claimant has the burden of proof. Let's just go back to Spiniarda. Sorry, and I should add now that explicitly there is a requirement in the civil procedure rules. It's contained in Civil Procedure Rule 6.37, subparagraph. Sorry, that's 6.37, subparagraph 3. the solicitor who, when they sign their affidavit or witness statement, in support of their application for permission to serve out the jurisdiction, must certify that he or she believes that England is the proper forum. And obviously they may be incorrect, but they must certify that they genuinely believe that England is the proper forum. There's a specific requirement to do that in your witness statement. To say, I believe England is the proper forum. Of course, the court doesn't accept it, but it's a beginning of the process. The court will obviously investigate that itself. Can we go back to Spiliado, which is on page 231? Well, in fact, I don't want page 231, I want page 233. And I don't want any of it, all of it, I just want to go down to the heading in bold, which is got 7 in brackets. Right at the bottom of page 233. This is in Spiliado. And you can see the heading, how does principle apply in cases where the court exercises its discretion under RSC Order 11. Do you remember what RSC Order 11 is or was?
Royal Supreme Ordinance.
Yeah, it's one of the predecessors to what is now the snappily titled Civil Procedural Practice Direction 6B, paragraph 3.1. RSC Order 11 is just what these days is those bases for service out of the jurisdiction. So, writing that in plain English, the Lord God is discussing how the discretionary element works in the service out case. That's what it is. Okay. But there's a short paragraph, and it's actually quite noticeable what he does say. In the last paragraph, on that very last paragraph on page 233, he says, the effect is not merely that the burden of proof rests on the plaintiff, this is an in-service out case, of course, to persuade the court that England is the appropriate forum for trial of the action, but he has to show that this is clearly so. In other words, the burden is quite simply the obverse of that applicable where a stay is sought, which is what we were saying a few seconds ago. So if I'm going to put it absolutely correctly, the claimant has to show that England is clearly the natural forum. And you see what the court is trying to do here. It's not trying to have sort of, 50.1% sure that confident that England is the natural forum. It's basically saying, look, there's something. Do you remember what we said a few weeks ago that historically, and I'll come back to this in a minute, it used to be said that serving out the jurisdiction was exorbitant. It was something that the court had no right to ask the court to serve out. It wasn't something that English courts historically did. All of the evidence is on the claimant, and the claimant's got to show that it's a clear case. If the court is not satisfied whether England or Florida on the balance of the evidence is the natural forum, then it won't serve out, because the claimant has to show clear, of course both sides will be presenting their arguments on the issue, but the court has to be overall satisfied that England is clearly the appropriate. Let me say that in my experience there's a gap between what the law says in the textbook and what actually happens in practice. Nobody will write it down anywhere for you, but there's a homing tendency in litigation. Courts quite often, if in doubt, despite what that says, find that they have jurisdiction, have a way of finding that they have jurisdiction under discretionary rules, even in what you might think are borderline cases. So although the law says the claimant must show that England is clearly the natural forum, I've certainly won cases, which I won't name, where I thought the evidence was pretty, at best, even either way. And the court said, I'm satisfied that England is the appropriate forum. That's just perhaps human nature of judges, in difficult cases, to be more inclined to take jurisdiction than not, but I can't prove it to you, it's not written down anywhere. So that is the discretionary test. Now let's have a look at something immediately, which I think, I think we'll take a couple of things immediately. Neither of which I'm afraid are in Hartley, but I think need explaining. The first one is this. Yeah, I'll take them in this order. There is quite an interesting judgment from 2 or 3 years ago in the Supreme Court, but which Hartley has not, I think I'm not extracted. It is from 2013, so 5 years ago now. a decision of the Supreme Court in a case called Abela, which is spelled like this, A-B-E-L-A. I can't give you a Hartley reference because to the best of my knowledge it's not in Hartley. Despite being a judgment of the Supreme Court, Abela, which is 2013 Supreme Court judgment. And in particular, let me just read this to you, what Lord Sumption says in Abela. He is talking specifically about the discretionary element of the service out test. I would not try, if I were you, I'll give you the paragraph reference, it's paragraph 53 that I'm about to read out. I think you'll get more out of it if you just listen to what I say and note it down and try and take down every word, which you can look up in your own time on the Westlaw easily anyway. Okay? Let me just read you what Lord Sumption says, because I think this is quite interesting. He talks about the judgment of the Court of Appeals and the court below him, where the Court of Appeal had used the language that I introduced a week or two ago, service out of jurisdiction being exorbitant jurisdiction, and therefore something that English courts should in doubt be reluctant to exercise. He says this. He says, this characterisation of the jurisdiction to allow service out is traditional and was originally based on the notion that service of proceedings abroad was an assertion of sovereign power of the defendant and a corresponding interference with the sovereignty of the state in which process was served. We talked about that before. But then he says this is no longer a realistic view of the situation. The United Kingdom, the adoption in English law of the doctrine of forum non-convenience, and the accession by the UK to a number of conventions on international jurisdiction, he's talking mostly about the EU regulation, means that in the overwhelming majority of cases where service out is authorised, there would either have been a contractual submission to the jurisdiction of the English court. What does he mean by that? Contractual submission to the jurisdiction. There'll have been a jurisdiction clause. Or else a substantial connection between the dispute and this country. And he says, moreover, litigation between residents of different states is a routine incident of modern commercial law. A jurisdiction similar to that exercised by the English court is now exercised by the courts of many countries. And then there are a few sentences which I'll skip, and this is the conclusion to this paragraph. It says, it should no longer be necessary to resort to the kind of muscular presumptions against service out, which are implicit in adjectives like exorbitant. The decision is generally a pragmatic one in the interests of the efficient conduct of litigation in an appropriate forum. So there you have a Supreme Court judge saying pretty explicitly, come on, we don't need to use the language in the 21st century anymore of service out being exorbitant, or there being a very strong presumption against it. You know, there's nothing exorbitant about taking jurisdiction over someone abroad because they've agreed an English jurisdiction. There's nothing exorbitant about taking jurisdiction over someone because they happen to be abroad. If England is the centre of gravity of the dispute, what's exorbitant? If the evidence is here, if the things we talked about the other day, if the witnesses are here, if the contract's governed by English law, come on, it's not exorbitant. Indeed, it's arguably daft to be so nervous about whether the defendant is or is not in the country. And he said, come on, this is a commercial, this is a pragmatic, this is a common sense view. Is England the right place for trial or not? If it is, we'll give you permission to serve out. If it isn't, we won't. Let's not. Words like exorbitant or disparaging words about people who ask us to service out are not a best consigned to the history. Okay? I did a search quite recently and found something like 78 examples in the last year of the word exorbitant, so I'm not saying that it has been consigned to history, but I think the general approach is a very powerful one. And actually, it seems to be right. I said to you weeks ago, it's slightly absurd in the 21st century to be talking about such an extraordinary difference between those who happen to be served when they're here for 3 hours and those who aren't. It's difficult to say from a commercial point of view, I think, and I certainly don't agree with everything Lord Sumption says in this area, but on that, it seems to me that he's right. Unless anybody thinks differently. It seems to be a sensible thing. So we are looking for the natural forum, but still it's got to be clearly the natural forum. There's just no negative connotations about people who are seeking. That's point one. Point two is slightly more difficult. Well, I don't think it is, but it needs a bit of explanation. Lord Gough has just said, I've just shown, well, it's in 1987, but I've just shown you. We've just seen Lord Gough said the forum convenience is the flip side, it's the mirror image of the forum non-convenience. But hang on a minute, it's not looking very flip-sidey at the moment. For one obvious reason. Here we have the stay test, and I described it on Tuesday as the two-stage or the two-limb test. How many limbs have we got on the other side? On the service out test? Yeah.
I mean, the thing is that in that part of the discussion, I mean, it's still an expiry proceeding. So
Initially?
Initially, yeah. So what should it makes more sense that there's not as such more than one stage that it is in the service as a right.
So let me give you an example. I'm one of the mine workers in South Africa. I'm trying to serve the defendant out at this time, out of the jurisdiction. But I can't show that England is the most appropriate forum geographically, in the sense of, on that side of the equation, we talked about that being an objective test, didn't we, on Tuesday, centre of gravity. I would never be able to show that England was the centre of gravity of that dispute because it wasn't. But I come to the English court and say, yes, but I can't get a fair trial in South Africa because I can't get a trial at all. In other words, my only argument for getting service out is as kind of a justice argument, not a appropriate one. Does the English judge have to say, sorry, can't give you service out unless you can show England is the centre of gravity of the dispute. You can't, it doesn't matter how unfair it is, how unjust it is, you can't have service out. Is that what Lord Gough meant? Because if it is, it's pretty surprising, particularly if it's an Article 6 ECHR kind of argument the claimant is making. We have a problem, don't we? Because it's not quite easy to see how the kind of justice argument fits into the test that Lord Gough himself has just laid down for service out of the jurisdiction. So some people, for a while afterwards, said, well, Lord Gough kind of meant that. What he must have meant is that there are two limbs to the test, and that the claimant can get service out if they show that England is the centre of gravity of the dispute. But maybe they can also get service out if they could show a strong injustice if they're not given permission. In another quite recent Supreme Court case, but another one that's not mentioned in Hartley, but from the same year, Isabella, 2013, this time in a case called, which I mentioned the other day, called VTB. Lord Mance said this. M-A-N-C-E. Lord Mance said this. He said, this is at paragraph 80. He said, permission to serve out the jurisdiction should only be granted if the court is satisfied that England is the proper place in which to bring the claim. It was common ground that this means that VTB could only succeed if it was able to show, in the words of Lord Gough in Spiliada, that the courts of England are clearly the appropriate forum for the trial of the action. Nothing new there. He then says that what Lord Gough is saying is that there is a single burden on the claimant. It is not a two-limb test, it is a single burden test to show that England is the appropriate forum for trial. And you might wonder what he means by that, because you would, as I say, I think you would expect a two-limb test if we're talking about the mirror image. But I think the language is more confusing. I'm talking about single-limb tests than the reality. And the reality, I think, is best shown by giving you an example of a case. I've already mentioned it a couple of times in this case, but we'll go to it now. This is a case on page 240 called Outano and Kyrgyz Mobile. This being a judgment in the Privy Council. So the Privy Council, a reminder for those who are not familiar, the Privy Council sitting in London is the highest court of appeal for a number of countries. It's not sitting as the highest court of appeal for England. In this case, it's sitting as the highest court of appeal for the Isle of Man. So it's sort of just the edge of Liverpool, really. So not very far away. But its status, although the Supreme Court occasionally decides that Privy Council judgments were wrong, usually what the Privy Council says goes and is followed in English cases as well. And this one is particularly influential because it is a judgment of Lord Collins, as in Lord Collins of Dicey Morrison Collins, the main leading prime international lawyer in the country. And this is what happens. I can simplify this very, very much. It seems to be. This is a massive kind of telecommunications dispute. And the claimants were trying to bring proceedings against a company which was based in Kyrgyzstan. The claimant was from the Isle of Man. The defendant is from Kyrgyzstan. And then we're looking for permission to serve out the jurisdiction with permission on a party company that was based in Kyrgyzstan and no place of business in the Isle of Man. The trouble is that the dispute, as the name Kyrgyz Mobile Telecommunications Limited rather suggests, was about the activities of a Kyrgyz company in Kyrgyzstan, albeit one that had entered into a contract with an Isle of Man company. The claimant needed service out of the jurisdiction, but it had one big problem. It was absolutely obvious on the facts that the centre of gravity of the dispute wasn't the Isle of Man. The centre of gravity of the dispute was Kyrgyzstan. In fact, that was even uncontested by the claimant. So if the service out test that Lord Gough laid down in Spiliada means you can never get service out of the jurisdiction unless you can show that England or in this case the Isle of Man is the centre of gravity of the dispute, then the claimant obviously lost. That would be the end of it. But the claimant made exactly the point that I made to you a few minutes ago. It said that can't be what it means. I accept that in most cases the way you prove that England is the most appropriate forum, or the proper forum, is to show that it's the centre of gravity of the dispute. That must be true in 95% of cases. But what it said was, look, I don't care if it's one limb or two, there must be an exceptional case where a claimant can come to the English court, or in this case the Isle of Man court, and say, look, I know that you're not the natural forum in the sense of the centre of gravity, but the injustice I would suffer if I'm not allowed to serve out would be so great that you should conclude that you are the proper place for me to litigate because of the grave injustice I would suffer outside if I wasn't going to serve. And the injustice that the claimant, I said we might come to some more coloured examples today, this is about as sweeping an injustice as could ever be alleged. The allegation for the claimant was that the entire legal system in Kyrgyzstan was corrupt. Full stop, pretty much. Obviously, they had a lot of evidence that they produced, and reports that non-governmental organisations had produced about Kyrgyzstan. But that was effectively what they were saying. This is a corrupt legal system. It will protect Kyrgyz companies. It will never let a foreign company be able to bring a damaging claim against a massive telecommunications giant that operates in Kyrgyzstan. We're never going to get a fair trial. So really, although I think this one wasn't really presented so much in terms of Article 6 of the ECHR, it was presented as that kind of issue. And you could see that if Lord Collins had said, no, I don't care whether you're going to get a fair trial or not in Kyrgyzstan. Isle of Man is not the natural forum geographically, so off you go. Whatever Lord Cobham said in Spiliana, that would be a terribly unattractive conclusion. Particularly as we know on this side of the equation that justice, we know now, the court has the flexibility to deal with situations that are fundamentally unjust. And Lord Collins said, despite this case being earlier than BTB, I think it clarifies it more. Lord Collins said exactly what I've said. Normally, you can't show that England is clearly the most appropriate forum without proving that it is objectively the centre of gravity of the dispute in exactly the way that is the mirror image of the first limb of the Spiliada test. In almost every case, you'll have to prove that England is the centre of gravity of the dispute. But there must be exceptions to that principle to deal with profound injustices where you can't. And this was such a case. So the first and most important point is don't be dazzled by the fact that it's a one-limb test. It's a one-limb test, but it is flexible enough to deal with pure arguments of injustice. Of course, we'd all, as lawyers, like it to be much simpler and say, well, why didn't the court break it down into two elements? If it's going to be an exact mirror image, and maybe it should have done. But it does, what he's saying is it doesn't matter. So let's not be fixated on that. The second thing that the defendant said is, as a matter of public international law, and as a matter of comity, which we talked about a few weeks ago, it's a disaster for English courts to get into issues like this. All seem quite attractive, maybe, and maybe you think it didn't, for English courts to have this sensitivity to decide on an exact fact of cases whether to exercise jurisdiction or not, in principle. But it takes it into some very difficult territory when it has to make these decisions. What is the English court being asked to do in this case by the claimant?
To override Kyrgyz jurisdiction.
Yes, and in particular, what's the claimant asking the defendant to make? What sort of findings about Kyrgyzstan? Yeah, that it's a corrupt legal system. Let's just take a reality check. In the late 1970s and early 80s, foreign non-convenience was extended, and was created and extended for reasons of comity. You've seen it yourself. Judicial comity has replaced judicial chauvinism. Remember that qualification we saw on Tuesday? Okay. Actually, it's created a whole load of problems as well, which, at least when you had a crude test that where people hardly ever got stays, ironically, you never got into these very, very sensitive questions. But what does Lord Collins actually decide? Well, let's pick this up about paragraph 95. He says the better view is that depending on the circumstances as a whole, the burden can be satisfied. That's the burden of showing that England is the proper forum. By showing that there's a real risk that justice will not be obtained in the foreign court. By reason of incompetence, quality of the judges, or lack of independence, or corruption. Of course, if it can be shown justice will not be obtained, that will weigh more heavily in the exercise of the discretion of the light of all circumstances. Is the court able to find that justice will not or may not be done because of endemic corruption in the foreign system? And the appellants had said there was overriding public international law reasons why you can't rule on that sort of thing. And he says at paragraph 97, comity requires to be extremely cautious before deciding that there is a risk that justice won't be done in the foreign country by the foreign court. And that is why cogent evidence is required. But contrary to the appellant's submission, even in what they describe as endemic corruption cases, i.e. where the court system itself is criticised, there's no principle that the court may not rule. And perhaps we could just pick that up again on paragraph 101, pages later. True position is that no rule that the English court or Manx court, for anyone who doesn't know their The adjective for the Isle of Man is Manx, so a Manx court. I'll make the reading any easier. True to this is, there's no rule that the English court will not examine the question whether the foreign court or the foreign court system is corrupt, lacking independence. The rule is considerations of international comity will mitigate against any such finding in the absence of cogent evidence. Otherwise, the paradoxical result would be that the worse the system of justice in the foreign court, the less it would be permissible to make adverse findings on it. And his conclusion at 151 there is no doubt that Kyrgyzstan is the natural forum. But the fundamental point in this case is if there's no trial in the Isle of Man, there will be no trial anywhere. Result? The claimant was allowed to serve out in jurisdiction despite the fact that it was, Kyrgyzstan was, as you've just seen there, not the natural forum. I mean, this is bad lawyers talk, it seems to be. It wasn't the natural forum, but it was the proper forum, is what Lord Collins concludes. But as I say, the best way of thinking about it is remembering as lawyers that when we read the cases, we often come across with 1 or 2% of unusual cases that make it to the highest court. In 95% plus of cases, you're going to have to show that England is the centre of gravity, the most expedient place to have a trial, but there's that tiny possibility of being able to serve out in cases of real injustice. Do you think the court's got it right? I mean, do you think the outcome of that case is right? Or do you find it slightly terrifying that the English court the English court is making judgments like that about an entire legal system? Yeah.
There's no doubt that this decision frustrates in some way the main rule, the rule of the center of gravity.
It does.
And it puts into a situation of quite, I would say, uncertainty and it's impossible to try to guess what the solution of the court would be with a certain, certain certainty.
I mean, that is there's a narrow point there, which is this is the absolute opposite of comity. I've already made that point. Yeah.
Yeah, actually, I disagree with this decision because it's some kind of discrimination of one jurisdiction with another jurisdiction. So this shows that English jurisdiction, I understand that it's very complicated, but it stands up then for the Kyrgyzstan jurisdiction.
Yeah, I mean, you could say it's quite offensive. I mean, Lord Collins is basically saying we won't make this decision very easily, and we'll need a lot of evidence, but we won't say we'll never make this decision. You could say that it's a fundamental problem, to take the wider point, with the whole way the system is set up. It sounds great, well, maybe it doesn't sound great, but it sounds the idea of being able to tailor the question of jurisdiction to the precise facts of each individual case can only be done with a discretionary system. If you have a rule-based system, you will get hard cases where the result seems unfair, but everyone will know where they stand. That's the theory, as long as the rules are clear. In a system like this, it's more tailored to the individual case because you get very, very difficult questions. The more practical problem, the wider practical problem is this. Do you think that what Lord Gough did in liberalising the test for stays, make it easier to get stays, and therefore correspondingly, I suppose, on the flip side, making it slightly easier to get service out as well, if you could show that England was the proper form. And there's a passage in his judgment where he said, in the future, these applications should be heard in hours, not days. Well, I can tell you that I've never been involved in one that's less than 2 days. Probably one that was 2 weeks, slightly over 2 weeks. But leaving aside that experience with may or may not be typical of other people, does it achieve its goal? Does it put the defendant on an equal footing with the claimant? And does it work commercially? Yeah.
Well, you have to enforce this judgment probably in Kyrgyzstan, and they will say that England didn't have any jurisdiction.
I don't think they'll be queuing up to enforce this judgment. Who of the Isle of Man courts in Kyrgyzstan? They'd be delighted with it. I mean, so that's an important point. It's got to be actually, but on the other hand, that's not a fair criticism of Forum on Conveyance generally, because remember where Lord started, he was agreeing with you, so we shouldn't hear as many cases. Just, you know, at least when we're talking about jurisdiction as of right, we should be giving up jurisdiction more than we used to. You know, whatever you think of Kyrgyz Mobile, the law on getting cases out of the English courts was you know, generally was much stricter in the past. From the defendant's point of view, if you were the defendant, you were on the other side of the world, how much comfort would you get from the existence of the Forum on Convenience doctrine? Obviously, it's better than having to show that the proceedings are vexatious or oppressive, if you're served as a right, which you had to do until the late 1970s. But what are you going to... let's remind ourselves of your options again. If you get served as of right, say, you're served with this claim form, you've gone back to New Zealand or wherever, except Japan, so you're a long way away, but then you may have no familiarity with the common law at all. You may be able to find lawyers locally who have any familiarity with any common law legal, let's say. Foreign non-convenience requires you to do what? What are you going to have to do even to get to the foreign non-convenience application?
Challenge jurisdiction.
You have to challenge jurisdiction, you have to instruct English lawyers. Am I going to be able to give the client very strong advice about whether they're going to win or not? If you were a lawyer and you're worrying about, on the one hand, the client wants commercial advice, on the other hand, you want to make sure you're not sued for professional negligence, are you going to tell, in most cases, the answer is not 100% clear, because cases don't tend to be like that in real life, are you going to be able to give the client 80–90% advice whether they're going to win or lose or not to make this application, do you think? I think most cases the clients often ask for percentages. And your answer in most cases in this is somewhere between 45 and 55%, if you're willing to be you know, quite bold in your estimates. The outcome is not always easy to predict at all. They are not dealt with quickly in my experience, as I say. They are very expensive. And one of the downsides of liberalising the test was exactly that. It's created more of an opportunity to challenge jurisdiction, but it's meant that a phenomenal amount of time and money is spent on these foreign non-convenience challenges and on these service out of jurisdiction cases. And I can tell you that most of these challenges, including service out cases, are not actually about whether one of these gateways has been satisfied. They're about the discretionary element, because you've always got a chance. And sometimes you will argue it anyway, because you think the other side will be so fed up of the thought of having to spend several $100,000 on jurisdiction before they even get to anywhere near a trial, and you threaten them that you'll appeal and you'll appeal and you'll appeal, that you may find that you know, that it's used as a tactic precisely to try and bring about some kind of settlement on proceedings. So it's certainly not true to say that what Lord Gough wanted, to simplify the law, is what has happened in practice. It's not always at all easy to predict what the final outcome of these cases is. On the other hand, if you are going to have a discretionary system, you are at least going to be able to, you know, and you never like the outcome of Kyrgyz Mobile. What at least you could say is the system allowed Lord Collins to get what he thought was the right answer, rather than reading a set of rules under the European rules and saying, yes, no, you do have jurisdiction, you don't have jurisdiction. And as I say, my experience is, whatever you think of foreign non-convenience, huge number of cases actually settle after this stage. Once people know whether they're in England or in a foreign, facing trial in a foreign court, and once they've spent several £100,000 already, you potentially have several £100,000 in costs in order to pay the other side's costs, the willingness to fight often diminishes, and you know, I would say maybe even more than half the cases I'm involved with settle after a very, very fierce jurisdiction. That tends to be the nature of litigation, sadly, that after people have had a bruising experience or spent a lot of money, they're somehow less willing to carry on spending money going to a very expensive trial. There we are. Okay. Should we talk about jurisdiction clauses now? And this material is, I think, directly related to what we've been talking about, but it's found in a different bit of Hartley. Some of the structure of this book is, in my view, slightly idiosyncratic. But there we are. We're around a page. We've gone backwards in the book. to around page 198. But let me be clear where we are in terms of this map on the board. We are now talking about, again, about cases of jurisdiction as of right. So we're down this column. We are talking about the discretionary element. So we're here again. But this time, we're faced with a situation where, although the claimant has started proceedings as of right, the defendant had a place of business here, or was an individual served here, the contract contained a clause saying that all disputes should be heard somewhere else. So let's say in the Texan courts. And in essence, the question could be reposed in a simpler way. Normally, a defendant's got quite a big onus on them. If they're served as of right, they have to prove that there's a clearly and distinctly more appropriate for it somewhere else. The question we need to ask ourselves is, should it be easy to get a stay in situations where the proceedings, where the parties have previously bargained for the dispute to be heard in a foreign court? Before I get to that question, a couple of preliminary points which are short but important. It's probably useful now to introduce a few different types of jurisdiction clause. And I think you'll probably know what most of these are if I just put them on the board and you can probably just shout out what it is. The most straightforward type of jurisdiction clause is a so-called exclusive jurisdiction clause. What is an exclusive jurisdiction clause? There's a fairly strong hint in the name. What's the, yeah.
When the parties agree that English or the branch British system, and that was
Yeah, and the second bit of what you say is what makes it exclusive. They agree that the proceedings must be brought in a particular court. Because an exclusive jurisdiction clause, like it sounds like, says the parties shall bring any proceedings in the courts of whatever country. It doesn't say anything other than, in other words, it's equivalent to saying they must bring proceedings in one specified country. That is the most straightforward type of jurisdiction clause, one that says, for example, all proceedings must be brought in the courts of Texas. If that's an exclusive jurisdiction clause, what is a non-exclusive jurisdiction clause? Or perhaps if you prefer, give me an example of a clause that would be a non-exclusive jurisdiction. What is a non-exclusive jurisdiction clause?
The defendant has any options.
Just the defendant? Okay, so give me an example of a clause involving the Texan courts. The parties, something in the courts of Texas. May, that would be a good example. The parties may bring proceedings in the courts of Texas. Clearly gives them the option to. But what's implicit in the word may? It's not shown, so where else might they be able to bring the proceedings? Anywhere else that would be prepared to exercise jurisdiction? And the short answer is actually that non-exclusive jurisdiction clauses take different forms. That's certainly perhaps the most common example. Parties may bring proceedings in the courts of Texas, or it may simply say this contract is subject to the non-exclusive jurisdiction of the Texan courts, which means the same thing, but it's just an unambiguous way of saying the same thing. You can do that. You don't have to. But other jurisdiction clauses are more tightly written, but still not exclusive. For example, if a clause said the parties may bring proceedings in the courts of Texas or in the courts of Florida, that's a different kind of non-exclusive jurisdiction clause, because it doesn't force you to go to Texas or Florida, but it doesn't. But it does let those are the only choices in town. doesn't say you can start in anywhere else that's willing to start you. It can let you sue. It specifies the only places you can sue, but it gives you more than one option. Because it could be 10 options or however many options you may want to. That's a non-exclusive jurisdiction. There's one other you may not have encountered, but which is incredibly important in practice. And that is sometimes called the asymmetric jurisdiction clause. It's somewhere between the previous two in some way. What is an asymmetric jurisdiction clause? Yeah.
Can I ask a question on
Yeah.
the before?
Yeah.
Wouldn't that be, if it's Florida or Texas, only those two, would it be shall bring it in either Florida or Texas?
It might say that. I mean, there are various ways.
Would that still be an on?
It's not in the narrative when we talk about exclusive jurisdiction, but we mean the clause that forces you to sue only one court. Okay? That's my point. There are different types of non-exclusive. Any clause that doesn't specify only one court only is probably best classified as non-exclusive. But there are different types. You know, you're right. You're certainly right to say that that type is completely different to the one that says the parties may sue in Texas, but which leaves any other court in the world that will take jurisdiction. What do you think an asymmetric clause is? Both of the examples that I've given so far, of course, at the time of contracting, you don't know who the claimant or the defendant will be. And both parties have got the same rights. Yeah.
Maybe one party is obliged to bring the claim in front of a certain court, and the other party has a choice to do it.
Exactly. That's exactly the kind of clause it is. A clause that specifies that, you know, Smith and Co. must bring proceedings before the courts of Texas, but says nothing about, you know, Brown and Co., the other party. Or it may be, in your example, I think you were giving exclusive for one person, but non-exclusive for the other. Smith and Co. Shall bring any proceedings in the courts of Texas. Brown and Co. may bring any such proceedings in the courts of Texas. It's asymmetric. It's not the same for both sides. Any clause that's not the same for both sides is called an asymmetric clause. They are particularly common in finance and banking, where banks like to force their customers to have exclusivity whilst preserving their own right to sue the customer in more than one place. Okay, so they're not theoretical, they really do exist in lots of types of contracts. Now, having said all that, and I will come back to them, and you will see much later on that there's a rather implausible and quite important issue about these types of clauses when it comes to the Brexit negotiations. I'm not going to cover that today. I'm talking about exclusive jurisdiction clauses today. Okay. One other thing. Another question that used to be incredibly difficult in the cases was the question of construction of jurisdiction. It was and is very common to find jurisdictions and clauses in contracts that say things like all proceedings arising out of this contract, or arising under, or all proceedings in connection with this contract, shall be brought in the courts of Florida. And that seems fairly harmless at the time of contracting. Can anyone see what practical problem that sort of wording could end up leading to when a dispute actually arises?
Is it the court actually has jurisdiction or lacks jurisdiction for all of the disputes, some disputes, towards arising from the contract? Or
That's exactly the point. You get into hard, potentially difficult questions about whether a claim arises out of the contract or not. An example I've given you already is, you know, if I'm your employee, so I have an employment contract with you, and I come to work one day and the floor is wet, and I fall over and I break my leg. Supposing I don't sue you for breach of contract, but I sue you for negligence, because I think I'll get more higher damages. Is that a claim that arises out of the contract? Depends what you mean by arising out of the contract, doesn't it? I mean, if I owe you £100,000 under a contract and I pay it for I pay it to you. But by mistake, obviously, I forget that I paid it to you, and then the next day I make a payment to you again. And I say, whoops, you owe me £100,000 back. Is that a claim arising out of the contract? Or is it a claim in, what might it be? For a very long time, lawyers made a lot of money doing the sort of thing that only lawyers would do, which is trying to construct claims, non-contractual claims, you see why you would do it, to avoid foreign jurisdiction clauses by trumping up negligence claims, restitution claims in England, equity claims, all kinds of claims to avoid this kind of language. And a horribly artificial set of cases arose about what the meaning of these kind of words meant. Now, anyone who's doing the arbitration may have come across this already, but it's important to say that about 10 years ago, it was actually a case on arbitration clauses, but Lord Hoffman made quite clear that the same principle applies is in relation to jurisdiction clauses in a case called Fiona Trust. Lord Hoffman said, basically, I'm sick of lawyers trying to make money out of this kind of language. And what he basically said was, look, as a matter of common sense, if two commercial parties enter into a contract and they say they want any disputes arising out of, or arising under, or arising in connection with, I don't really care actually, their contract, what do they obviously mean? From a common sense point of view, what do you think they mean? Only strictly contractual claims, or any claim that in any reasonable sense could be said to be sufficiently factually related to the contract? That's just commercial. Why would you bother bargaining about where you're going to litigate and then allow that clause to be evaded by bringing a non-contractual claim? Of course, you might be glad your lawyers thought of that strategy when you've got a dispute. But if you ask them what people mean in their contracts, they're talking about, they mean one-stop dispute resolution, don't they? Contractual, non-contractual, I don't care. And he said that there should be a very strong commercial presumption that you don't dwell on the language too much, that people intend one-stop dispute resolution. And actually the contrary should be true. If you don't intend, if you, for example, if you don't intend non-contractual claims to be covered, the clause needs to be very explicitly drafted to make that clear. Of course, you can retract what you want. If you and I want to agree that only our contractual claims, and for the avoidance of doubt, any non-contractual claims or claims in unjust enrichment shall not be covered by this clause, of course we can do that. Why shouldn't we be able to do that? But he said, you know, we're not going to consign to history all these cases about the exact meaning of language. And so what he is basically saying is that at least when the contract is governed by English law, English courts will start with a broad interpretation of what clause means. Which I think it must be common sense. Those are my preliminary points. Let's go back to the question I was actually asking. How does all this map onto the discretionary element? And here you can see why talking about just exclusive jurisdiction clauses simplifies the point. Does anyone think it should be a lot easier if I've served you in England as of right, but you and I had agreed that any disputes between us should be heard exclusively in the courts of Texas? Does anyone think that you as the defendant should have an easier task in being able to ask the English court for a stay than if we'd never bargained? Yeah.
And do you think that the burden of proof relies on the claimant to prove why he shouldn't be staked to this agreement?
That's certainly correct as a matter of principle. What is the claimant doing now that the claimant certainly wasn't doing in the previous examples? If I start proceedings against you in England as of right, okay, it's as of right, I accept that because we've seen that through. But you and I have bargained that any proceedings must be brought in Texas. What am I doing when I start proceedings against you? What am I committing?
You're not abiding to your word.
Let's put it even more bluntly. I'm in breach of contract. Now, I'll come back to this in a week or so's time. But one way of thinking about a stay in this situation is that it's basically a remedy for breach of contract. You all know remedies in our legal system for breach of contract. You all know the remedy of damages. Do you know what? A stay, so asking for a stay because somebody has sued you in breach of contract, is quite a lot when you think about it, like asking for specific performance. your agreement. What you're saying is, we bargained for taxes, so I ask you to enforce that clause, not by giving me money, but by making the claimant stick to that clause and going off if he or she or it wants to sue me by going to Texas. And so it's not at all surprising as a matter of principle that when you're talking about exclusive jurisdiction clauses, you're talking about breaches of contract. And it would be pretty extraordinary if the English court said, no, I don't care, unless you can show a defendant that England is not the, that Texas is more appropriate for him, you can't have this. Now, that analysis works with exclusive jurisdiction clauses. It may well not work with, of course, with non-exclusive ones, because if the clause had said the parties may bring any proceedings in the courts of Texas, is it going to be a breach of contract to bring proceedings in England? And that's a very good answer, if I may say. Not if the clause just says any proceedings may be brought in the courts of Texas, because it doesn't say that they can't be brought elsewhere. But in my second example from earlier, if the contract said any disputes may be brought either in the courts of Texas or Florida, is it a breach now to bring proceedings in England? And the answer is, of course, yes. So non-exclusive jurisdiction clauses, it may or may not be a breach of contract to be suing in England. It depends what the court says. In an exclusive jurisdiction case for a foreign court, it's always going to be a breach. Now, to be clear, we are only talking today about jurisdiction clauses in favour of non-EU and non-Lugano countries, so not the EU countries, not Norway, Iceland, and Switzerland, and not England either. I'm talking about the rest of the world. Clauses in favour of the rest of the world. Because if the clause was in favour of Belgium, for example, we'd be talking about the judgments regulation. We'd be talking about a completely different Belgium. Now, you talked about this discretionary approach, but let's just stop here. Why should the English court have need a discretionary approach here? Does anybody think the English court should just immediately stay its proceedings as soon as it shows that the clause is valid and the dispute? Obviously, the defendant has to show that the clause is valid, in other words, the contract containing it is valid, and has to show that the dispute falls within the scope of the clause. Yes.
Because the claimant might suffer injustice if it's ruled in the case.
Okay. Whether you're familiar with the judgments regulation or not, the answer under the judgments regulation is pretty much tough. You know, if you bargain for it, then you can't then turn around to the English court. If you said, I will sue in this jurisdiction, you can hardly then turn up in England and say, oh, well, actually, I don't really want to. Okay? And that is pretty much the rule under the European rules. On the other hand, the European rules are balanced with all kinds of intrinsic checks and balances, and in particular, weaker parties already have protection, consumers, employees, because jurisdiction clauses don't generally work in that kind of contract, whereas the common law rules have no special protection for weaker parties, for consumers and employees. Well, let's have a look at some law, shall we? I mean, I don't think we need to dwell on the Fairman very much, which is on page 198, although we perhaps should mention it briefly. To create some space, because I'm not talking about service act for the rest of the day, I'm just going to go over here. So in the Fairman you have a dispute between an English buyer and a Soviet shipper from the Soviet Union, as it then was. Quite a striking dispute, because the contract said that any disputes should be heard in the courts of the Soviet Union, and I might add, the dispute was governed by the law of the Soviet Union. But as against that, the claimant was English, and the goods had been carried to a port in England. There were, I think hardly it's fair to say there were probably roughly equal connections to the Soviet Union and England in terms of facts. I think that's really just have a look at the first. So the defendant served as of right and asked for a stay on the basis that the claimant is suing in breach of this jurisdiction clause in favour of the Soviet courts. If you have a look at the most important paragraph in this extract, it's the very first one, really, probably the only one we need to go to. Lord Denning says about 3 lines down the end of the third line, he says, I say that the English courts are in charge of their own proceedings. And one of the rules which they apply is that a stipulation that all disputes should be judged by the tribunals of a particular country is not absolutely binding. It's a matter to which the courts of this country would pay much regard, to which they would normally give effect, but subject to the overriding principle that no one by his private stipulation can oust these courts of their jurisdiction in a matter that probably belongs. Okay, it's 60 years ago. But Lord Denning is making almost a public law point, which is the jurisdiction of courts is derived from ultimately from constitutional law, and the function of various organs of state, government, the executive, the courts. And it's not open to parties by their private agreement completely to take the jurisdiction of those public bodies, those public organisations, the courts, away from them. And therefore it shouldn't be completely within the party's control whether the English court takes jurisdiction. Okay, it's 60 years ago. Do you have any sympathy for that view or not? I mean, where in commercial perspective it seems terribly old-fashioned, I think. You know, if parties entered into a contract, we're used to them being held to their terms of their contract. I think what they're saying is a jurisdiction clause is not just any old contractual term, because you're trying to contract in or out of a public body. And that is not something for which you should have complete freedom of contract. Do you agree?
Maybe it was in the context of the Cold War.
Yeah, I mean, certainly this is a case where the Lord Denning was probably not very keen to reach the conclusion that the English buyer, in relation to goods that were in England, had to go and sue in the Soviet Union. I'm sure that's right. But the principle he's stating in that one sentence at the end of that paragraph, that it's almost a matter of public law, and therefore it's not completely within the power of individuals to choose whether the courts do or don't have jurisdiction. Do you sympathise with that view? Who doesn't sympathise with that view? Yeah.
I think parties are, able to contract and do whatever they want. So if they want to contract, if they want to have jurisdiction clause in something that's completely unrelated.
Would you say it was the other way around? If everybody wanted to choose the English courts, that the English courts would have to deal with them just because they'd chosen them, no matter how long the waiting list got? I mean, you might respond, it's not that way around. This is the English courts being asked to give up their jurisdiction, not to stubbornly insist on it despite the parties' agreement. What do you say?
I think the choice of jurisdiction is not generally a mandatory rule, so the parties can extract jurisdiction, decide their dispute settlements. When
I mean, it might be different if we were talking about a standard form contract and a consumer who basically been told take it or leave it, and you might think it's a very unfair kind of agreement or something like that. But this is not that kind of agreement. And as you say, you know, there was a political element to this case, and Lord Denning went on to say that he was going to hear the case. But I don't think, if you think this is surprising, you may be even more surprised next term to see that the US courts, until even later than the Fairman, were saying the same sort of thing, that jurisdiction is a matter of public law, not private law, and whilst we would give deference to what the parties' wishes are, it's not completely within their power to take jurisdiction away from them. I don't think, in reality, any commercial law judge actually thinks that anymore. They do think sometimes what people bargain for turns out to be very different, you know, because events take place. We'll see an example of that in a minute. But I don't think that that principle really holds true very, very much anymore. And the modern principle has really survived. The modern principle, what is striking about it is it's significantly older than Spiliada itself, the modern law, and how foreign jurisdiction clauses are dealt with. And the decision that Hartley's given you there, the Eleftheriot, is only a trial court decision, first instance High Court. But that principle has been followed from 1969, has been followed ever since. And as I say, I repeat myself, but it's significantly older than Spiliada itself, which was 1987. So here you have goods being carried, this is obviously well before there was any European convention in force in the United Kingdom, from Romania to England on a Greek ship. This is page 200. This time you have a Greek jurisdiction clause and a Greek applicable law clause. The goods are supposed to have been delivered to a port in England, in the north of England. But because of industrial action at that port, they can't get to port. And so instead, the goods are delivered in the Netherlands, rather, and that's part of what the dispute is about. But the goods were dropped off in the Netherlands rather than in the north of England, which wasn't particularly convenient from the claimant's point of view, but there we are. The principle, the question that the English court has to ask is whether to give effect to the Greek exclusive jurisdiction clause. And certainly this time the conclusion is the opposite, much more in accordance with subsequent cases. The jurisdiction clauses are there to be given effect, absent a very good reason why they shouldn't be given effect. And in this case, a stay is granted in favour of the Greek course. That's not what's of so much interest as what Mr. Justice Brandon says. Have a look at page 200. He summarises a number of principles. The first one, on page 200, could be summarised as an English court doesn't have to grant a stay where there's a breach of a jurisdiction clause, but it always has a discretion. Good old common law discretion. The second point is actually the best statement. It's only one sentence long, but it's the best statement of the law in 2018 on what English courts do in this situation in terms of granting a stay where there's a foreign jurisdiction clause. And he says, discretion should be exercised by granting the stay unless strong cause for not doing so is shown. Question, who has the burden of proof? So effectively what we've got is a reversal of the burden of proof. We know now in 2018 in what I might call normal Spiliada cases, the defendant has the burden of proof. But where there is where the defendant has proven that the claim is being brought in breach of a foreign jurisdiction clause, the burden is not on the defendant, the burden is on the claimant, in this kind of case, to show strong cause why it should be allowed to sue in England. What does it look a bit like, that discretion? It looks an awful lot like we talked about earlier today. That burden is called strong cause why you should be allowed to sue here. In other words, it could be a really good reason why you should be allowed to breach your contract and sue. But in practice, it's not a million miles away from the obligation on a claimant who's seeking service out, which is to show clearly why England is still the right forum. It puts the burden on the claimant, in this kind of case, in a way that in practice, although the language here is strong cause rather than natural forum, you'd be a brave individual to tell me what the difference is in terms of what the kind of factors you point to before an English court to show strong cause. I can tell you that if you're representing a client who's suing, as I've only once had to do, a defendant in glorious breach of the jurisdiction clause, in all likelihood the judge is going to be very cross with your client and therefore very cross with you, or even having the temerity to stand up and argue that you should be able to sue in England. You're going to have something pretty convincing to say in that case, yeah.
Should the plaintiff show proof on the initial claim, or once the defendant has already challenged the jurisdiction?
You don't need to show any proof. I mean, as a claimant, all I do is plead my claim on the merits, and then I see whether the defendant challenges jurisdiction or not. But the reality is, I know I'm getting, 90% likely to get a jurisdiction challenge if there's a breach of a
So when the
jurisdiction.
event doesn't challenge, then you would obviously.
I'd be advising my client before we start the claim, look, you're probably going to have to face a horribly difficult time in a jurisdiction argument. You need to have something very convincing to say. And sometimes the client will say, well, I know, but I'm not prepared to sue in that forum, so I'm going to give it a go. And as long as there's something that I professionally can argue, not completely unarguable, then I have to go and do that and get shouted at by the judge. Been there, done that. And I should say to you, and I imagine that's the experience of most practitioners, I have never won. I have never been involved in a case for or against. In fact, where an English court has not stayed to give effect to a foreign exclusive jurisdiction clause. Never. And again, cases in a book can mislead you as to how often that actually happens. Just looking at those exercises then, the burden of proof then is on the plaintiff, we see that point 3. And then Lord Brandon gives a number of factors. In point 5, what is striking? I won't go through this, it will take up unnecessary time. What is striking about the list of factors that Mr. Justice Brandon goes through in 5? Where's the evidence? 5A. What law applies? 5B. Where are the parties from? 5C. What are those factors? The actual factors that he is saying are relevant to showing strong cause why you should be allowed to sue in England. What do those factors all look like? I'm thinking about, what do they look like? Sorry?
The gateway.
I don't think they look so much like the gateways. What do they look like?
Which ones?
I think all of the ones in number 5 through to Roman numeral 3. That's 5 A, B, C, D, and then E 1, 2, 3. They all look like the kind of factors that would equally be relevant under the first Liddon-Spilliard test. They all look like, here he is, 18 years ahead of his time, talking about the kind of things that will be. Actually, if you look at what it says on the page, how many percent? You've got to have a really strong cause why you're suing here. It's breach of a jurisdiction clause. You might think a strong cause would be radical injustice, unfair trial in a foreign forum. It's actually rather easier than that. He is envisaging that you could show a strong reason why you should be able to sue here, simply by basically showing that the centre of gravity of the dispute is in. There's a mismatch between this very strong language. You must show a strong reason why you can sue here, why you're suing here, in breach of the jurisdiction clause. And what he actually then goes on to say are strong reasons, which are basically the evidence is here, the witnesses are here, and it's given by English law, which are basically not really more than factors which amount to saying it's more expedient. England is the forum convenience. And that's unfortunately what people do in these cases. They don't win very often, but they still argue, okay, the claimant has the burden of proof in this case. The claimant will still just list all these factors and produce huge evidence about where the witnesses are and what the applicable law is and all these kind of objective factors. And the judge will ignore them in the end and say, well, I hear what you're saying, but tough. You chose to sue in that forum, so I've got no sympathy for you. But it doesn't stop people on the back of what Mr. Justice Brandon said in the Alathra, saying that strong cause could be things as simple as where the witnesses are, where the evidence is, from adducing all that stuff. What about the very last one, which is on the top of page 201? What does that look more like? Political, racial, religious, or other reasons are likely to be a fair trial. That looks more like the justice element of Spilliard. Yeah, you can see that, can't you? Nobody could really say, look, you might say you'd be quite a strong-willed judge. Perhaps you might say a heartless judge, to say to somebody, look, I know you can't get a fair trial there. I know you'll be subject to bias or discrimination, but you chose it in your contract so tough. That would be a pretty robust thing to say, particularly if it was obviously true. Imagine in Kyrgyz Mobile, I know it was a Senate case as a bad example, but imagine it had been as a right jurisdiction case, and the parties had agreed a Kyrgyz jurisdiction law. So if Lord Collins had said, well, you chose Kyrgyzstan, so that's really just tough. That would have been, whether you agree with the case or not, it would have been quite a robust conclusion for him to reach. I know that I'm satisfied that Kyrgyzstan is a endemically corrupt system, but tough you chose it. Your fault for choosing an endemically corrupt system. So, whether you agree with that or not, is a less surprising example of what a strong cause would be than actually what the, so really, if you ask me what the overall test is for a stay where there's been a breach of an exclusive jurisdiction clause, it is clearly still that the claimant has to show strong cause why it should be allowed to sue here and breach that clause. If you ask me what are the constituent factors of that test, actually I can't tell you that they're very different, apart from the claimant having the burden of proof. The claimant can point to almost anything that it will be able to point to under the Spiliada test. But I can tell you that unless you've got a very strong case, the judge is going to be very cross with you and is going to refuse is going to grant a stay, certainly in 2018. He's not going to take a Lord Denning Fairman kind of view of you're ousting the jurisdiction of the English court, so I will, I will be with you. And in the end, the conclusion of Mr. Justice Brandon was, in this case, look, some of the evidence is here, but really this is just tough. You chose to litigate in Greece, and you should be stuck with that decision. And that's just when might you get further? Well, there's two examples perhaps we can take in the time we've got. One is so unusual that I almost tend to say we shouldn't spend too much time on it because no example I'm aware of has ever arisen since, but we perhaps can take an example of what Mr. Justice Brandon was talking about, political, racial, religious or other reasons unlikely to get a fair trial. There's an example of that in, again, this is still pre-Spiliada in the Carvalho case. Rather than take you through the whole set of facts, let's just simplify this. It's on page 203. This is a dispute between a Portuguese claimant and an English defendant called Hull Blythe, but despite the name Hull Blythe Limited, it did most of its business in the country of Angola, which at the time was a Portuguese dependent territory, effectively part of Portugal. A separate jurisdiction, but effectively completely under control of Portugal. So here you have a Portuguese claimant suing an English company that does most of its business in Angola. The parties bargained for any disputes to be heard in the courts of Angola. Then what happened? So the claimant from Portugal, defendant from England, all of this again before the Brussels Convention is enforced in England. What happened in Angola?
Independence.
Yeah, and in particular, there was a civil war, independence. What were the claimant's prospects of starting proceedings pursuant to this clause in Angola? I think that's a fair way of putting it. Claimant had fled the country and could never go back. A bit like, you remember the Mohammed and Bank of Kuwait case we talked about on Tuesday, in a similar kind of situation. As I say, let's not pretend that this is the kind of situation that you get in the commercial courts, on a wet Friday in November, because it's not. I mean, this is but if you want a graphic illustration of what might be strong reasons, I think the way that the court puts it, if you could look on page 204, Lord Justice Brown's judgment, in the, I suppose it's the penultimate of the paragraph leading us over the last couple of single lines, he says one perhaps can test it in this way. The parties are known in December 1973 what the situation would be in Angola. Now, would they have agreed to include the clause in the contract? I think it's impossible to say the answer must be yes. If you want to put that in contract terms, right, I mean, so you could put it two different ways. One is there's a grave injustice, or there's no possibility of a fair trial. all of which are, I think, to use the language of the LF, are obviously strong reasons why you should be able to breach the clause. If you wanted to put it another way, what might you say about that contractual clause now that there's war? Yeah, a common law language might be to call that clause frustrated or force majeure. It's not quite clear what the judge is saying, whether it's so unfair that you shouldn't be held to it, or actually the clause doesn't apply at all because of force majeure or frustration. The clause can't possibly, must be released from that clause because they can't possibly have expected it to apply in this situation. Either way, all roads lead to the same conclusion, which is you should be allowed to sue in English. An interesting example, but not one of much practical commercial use, precisely because it is so expensive. The modern position is much closer to the one, a case that we're going to come back to when we look at antecedent junctions. But if you look right at the bottom of page 207, probably a case that should have been extracted, but I'm going to talk to you about it next week anyway. You'll see reference to a case in the House of Lords called Donahue and Armco. You see that about 4 lines up from the bottom of page 207. That statement from Lord Bingham that probably should have been extracted is much closer to what any commercial court judge will tell you in 2018 if you sue in breach of a jurisdiction clause, except in truly unusual, remarkable circumstances. Right at the bottom of page 207, which is parties who, where parties have bound themselves by an exclusive jurisdiction clause. Notice the reference to exclusive jurisdiction clause. Effect should ordinarily be given to that in the absence of strong reasons for departure. That is what Mr. Justice Brander said in 1969, still being the law. Okay. But that is not a trial court, that's not the Court of Appeal, that's the top court in England, confirming that the strong causes test applies. The way it's put in another case around the same time, a case called Ace Insurance, by another judge, Lord Justice Rex, he said, if a party agrees to submit to the jurisdiction of a court of a state, it does not easily lie in its mouth to complain that it's inconvenient to conduct its litigation. Lord Justice Rex said in Ace Insurance, it doesn't really lie in your mouth to complain that it's very inconvenient to sue in a place. If the answer is well, tough, you should have chosen it. But there is one more commercial example of where jurisdiction clauses aren't enforced. And again, I think this case probably deserved to be extracted in itself, but I think it's a better example than Carvalho. And that is the case of the Hollandia, which you'll see discussed, although no extract, in the last, starting on the last paragraph of page 205. And I'll cover this if I may, Dan, and that will take us to the end of the session. Quite interesting as well, I think. Some of you may know what I'm about to say by way of background because you may have done shipping or carriage or be doing it. Some may not, so for the avoidance of any problems, let me just explain what this is all about, the Hollandia. This is all about, this is a case that's all about bills of lading. In other words, the document that is used in carriage of goods by sea contracts. Now, what happens, for those of you who don't know, is that in the most common example is that a ship owner will issue a so-called bill of lading, which is evidence of the contract, to a shipper, a carrier. And that becomes effectively a contract with the ultimate buyer. By transferring the bill of lading to the carrier, the carrier ends up being effectively, by a form of kind of assignment is not really the right word, but ends up by a statutory mechanism being effectively in a contract with the buyer on the terms that the ship owner had originally set. The thing that was worrying many people as long ago as the early part of the 20th century was the phenomenon of ship owners and carriers basically trying to exclude any liability for damage to the cargo to the buyer, so what's called the consignee, through exclusion clauses. Either exclusion clauses saying I have no liability for damage to carry to the cargo at all, or clauses saying my liability will be limited to a very, very low amount. It was particularly important in the UK because so many of these contracts were governed by English law, but it was considered to be a worldwide problem of unfairness to buyers of these take it or leave it kind of clauses. And so there was enacted, well, although it's called the Hague Rules, they are basically an international convention. Of 1924. Now, the Hague Rules of 1924 basically didn't say carriers can't limit their liability at all, but they basically said they can't limit their liability below a certain amount of money per package, which was calculated by a formula of how much it weighed and various things, which we don't need to know about and I don't know about, so I couldn't tell you about it if you wanted to. So the idea is, if you're talking about liability of a carrier in, let's say, pounds or dollars or whatever it might be, there was a minimum level below which you couldn't exclude. You could impose a higher level, you didn't have to have a limitation clause, but you couldn't exclude below a level which at the time was, in sterling was, sorry, we still have it, sterling was £250 per package. Now, what they should have done in 1924, of course, is have a proper two things. Firstly, was to have a review clause, and secondly, to be able to account for inflation, because £250 was no doubt an awful lot of money in 1924, but wasn't so much money years down the line. And so in 1968, more than 40 years later, the Hague Rules were revised by another international convention called, not very imaginatively, the Hague-Visby Rules of 1968, which the UK brought into force in the UK quite quickly by these standards in 1971. They became part of English law in 1971. But the UK was one of the first countries to fully ratify and bring it into English law. That convention basically raised the minimum liability of a carrier, which they couldn't go below, by a huge amount of money, from £250 a package to about 11,000. Okay. Let's call this the Hague-Visby limit, and this the Hague limit. This was a pretty strong policy, saying, affecting and damaging, in their eyes, the UK shipping industry, of people trying to reduce their salary, reducing their liability. So, what's the problem that people, how could potentially an English carrier or ship owner get out of the problem that the English courts might not, that the English courts impose this high limit on them that they can't exclude liability below 11,000? What might they try and do?
Exclude English jurisdiction?
Exclude English jurisdiction by choosing
Another form.
From an English point of view, that's just too easy, isn't it? Because all this trouble to have an international convention to make sure liability can't be restricted below a certain amount. Oh, well, I just won't go to the English courts then. Okay? Meaning that the poor buyer finds, who may be an English buyer, was finding, or potentially finding, that although the Hague-Visby rules were enforced in England, the contract, which there was basically a take it or leave it contract by accepting the bill of lading, said, well, any disputes will be heard in some other country. Okay? And that's what happened in the Hollandia, because the English buyer was subject to what was basically a take it or leave it jurisdiction clause in favour of the Dutch courts and Dutch law. And notwithstanding that The Hague is in the Netherlands, at the time of these proceedings, the Netherlands had enacted the old 1924 rules, but not the 1968 rules, not the 1968 Hague Visitor version. So the UK, at the time of these proceedings, the English court had the higher minimum limit of 11,000 per package. The Netherlands had £250 per package. The carrier would be an awfully lot better off if the proceedings were brought in accordance with the jurisdiction clause. But the English buyer obviously did not want to sue in accordance with the jurisdiction clause for exactly that reason, because the liability would be much lower. So the English buyer brings proceedings in England. Again, obviously long before the EU rules of jurisdiction. Basically says, I've got strong reasons in modern parlance to bring these proceedings here. What is the strong reason?
Basically, if he wouldn't be able to sue in England, and he would be deprived for the higher liability that's established in the English law. But that has, the Hague would be adopted by the English law.
Yeah, and that was his argument. Was it a good argument?
He was forced to take a little bending, probably wasn't the argument.
Is it, I mean, why is this example different to the previous, to some of the previous examples we've looked at? Is this about the personal injury? I mean, it is about the personal unfairness to the buyer, but is that the main, from the English court point of view, is it this particular buyer that the English court thinks is suffering an injustice, or is it a much wider point?
Buyer in general. Or the shippers trying to elude responsibility by excluding British ports.
Yeah. What were you going to say?
It's a matter of public policy
Why?
because they avoid English legislation.
Yeah. What were you going to say?
It completely undermines English legislation, just find a way around it.
Yeah. I mean, I think all of these points are right, but particularly the points that you've made there, which is, I'll put it a different way. If you ask yourself what was the intended effect of this statute, because it is a statute here, albeit one giving effect to an international convention, the Hague Visitor Rules were enacted in an English statute, okay, good for the Act 1970. Do you think that statute was intended to override foreign jurisdiction clauses? Or put it another way, do you think Parliament's intention was that you should be able to just get round the policy that carriers must not limit their liability below £11,000 by choosing foreign jurisdictions? If you ask it that way, it's almost a matter of statutory construction, isn't it? But as you all say, the whole policy of the Act is that it must not be evaded by the expedient of choosing a foreign court. It's sometimes described as a mandatory rule of the English law. The whole point of the statute would be immediately undermined if you could just get out of it by choosing a foreign court. And therefore I do think it's very different to every example we've looked at so far in the course. It's not just this buyer, in fact, I think you were saying it was, but this buyer was an example of a wider problem, that the whole law, the law would be rendered a nonsense if you could get out of this liability. Yeah.
Wouldn't the jurisdiction clause, which would the contract out would undermine the law, be contrary to law, and in that sense also be sort of invalid?
Yeah, I mean, there are two ways of looking at this. Was the court saying there was strong reason to let you sue here, or was it simply saying the whole jurisdiction clause is invalid? I don't think the court very clearly distinguishes between the two. I think you could say that the whole clause should be invalid, which brings me to the next and perhaps last point. Does that mean that all foreign, okay, you're not like to get this exact situation again, but you do certainly get contracts of this type where it doesn't make sense to be able to exclude the English courts jurisdiction. The classic example would be health and work, employment rights, or health and safety of work. That's an even better example. If you set up if I decide to set up a factory in the north of England tomorrow, I wouldn't do a very good job of it. But there will be all kinds of legislation about health and safety of the premises, and about how I have to treat my employees. Not necessarily I don't know anything about payment, but they're just their welfare and their safety. And they're designed to apply in the United Kingdom. Okay. Would it make sense for me to say, well, if you have any disputes with me about all this, they're all governed by the law of Delaware, and I'll see you in the Delaware courts? Probably the English courts then would say, oh no, hang on a minute, that's a kind of mandatory rule. Employment rights are to be enforced in the English courts. So it's not, although this is an old problem, it could arise in almost any. Now let me ask you another question. Do you think any proceedings in any other country would have, sorry, I've not answered that question very well. Do you think it wouldn't have mattered what country courts and law had been chosen? The English courts would still have declined a stay? Or do you think it might have been relevant which particular country and which particular courts were chosen? What was significant about the Netherlands on these facts?
It didn't adopt the HSP rule.
Hadn't adopted them yet. So to answer the question,
Depends regarding the adoption of the HSP.
yeah, I don't think that this case goes as far as to say that jurisdiction clauses will never work. But it will go as far as you say, a sort of public policy